we're talking about different types of pleadings. Okay, from the class now, can somebody name some of the ones you know? Different types of pleadings.
Statement of claim.
Statement of claim. What again?
Statement of defense.
Statement of defense. Any other thing? Counterclaim. Any other thing? Reply. Set up. Any other thing? You say what? Written address. No, it's not a pleading. We are talking about pleadings.
Reply.
Somebody has mentioned reply. Okay. You didn't remember rejoinder. There's something called rejoinder. Okay, we start talking about them one after the other. So what we need to do here is identify them and talk about the rules guiding them. Now, the first one here is statement of claim. Statement of claim is a concise statement of facts by the claimant. It's a concise statement of facts by the claimant in which he states his case, in paragraphs, in which he states his case in paragraphs. The rules guiding statements of claim also applies mutatis mutandis to every other type of pleading, but with little difference. The rules guiding statement of claim applies to other pleadings in all forms, but with little difference. Every pleading or statement of claim must contain statement of facts and not evidence. Must contain statement of facts and not evidence. Must contain statement of facts and not evidence. Some of the times it is difficult to differentiate between facts and evidence because facts themselves constitute evidence. Facts themselves constitute evidence. So in some cases, it is difficult to know the difference between the two. But suffice it to say that what the law requires is a concise statement of the facts which may be expatiated during evidence. The idea is to ensure that a statement of claim is not verbose. The idea is to ensure that a statement of claim is not verbose. Every pleading must be able to give the necessary particulars where necessary. Every pleading must show or state the necessary particulars where necessary. I will explain that. Necessary particulars. First, before I leave you, give me a list of everybody in the 10. Where necessary. Some issues that require statements of particulars are: 1, allegation of fraud. Specific denial. allegation of negligence, etc. Allegation of negligence, etc. So I'll give you an instance. If maybe while I'm couching my statement of claim, and it won't be enough for me to say that A played fraud upon my client, and then I'll leave it at that. No, it will be hanging. So I'm obligated to do what? Tell us what is the act that constituted the fraud. I must be able to show whether that act is a fraudulent misrepresentation or whether it is an innocent representation. So it is only my particulars that can do what can differentiate. And if I'm alleging negligence, maybe that the university owed me duty of care as a student, I must be able to state, if it's possible, under which law. I may just mention it, the law that says that the university owed me duty of care in so material respect. What is that duty of care? How were they supposed to discharge it? I'm talking about particulars now. What did they do instead of discharging their duty? So that somebody who is reading it will look at the particulars and say, yes, I agree with this person, that there is what? Negligence. The same thing can also occur when I'm claiming for special damages. I must be able to give particulars of the special damages. Special damages is different from general damages. It's different from what we call exemplary damages, or what we call aggravated damages. But each of them, it will be good to do what? To particularize. But when we're talking about special damages, you're talking about something that happened with specificity. You know, for instance, you say, he came into my land, destroyed everything on my land, and the cost of what he destroyed is 20 million naira. If I leave it like that, will I succeed? I will not. I will not. I must be able to particularize. He cut my iroko tree, worth 10 million naira. He destroyed my cassava, all those things, was also amount of money. And if there is any expenditure I made that is shown by a receipt, I must be able to quote it and what attach it. That is being particular or specific on what I'm talking about. Now, at the end of the facts, a statement of claim must seek for reliefs. You must seek for relief, and that is the concluding part of your statement of claim. Your relief simply would ask, tell the court, I want a declaration that I'm the person entitled to statutory right of occupancy over the land in dispute. B may be a declaration that the sowing of the tree on my land by the defendant without my permission constituted an act of trespass. C, the sum of 50,000 naira against the defendant for trespassing into my land. E, perpetual injunction restraining the defendant, his servants, agents assigned from further acts of trespass into my land, or in any other manner using the land or tampering, interfering with the land in a manner that is inconsistent with my rights. So those are my prayers, and then I conclude. Those are my reliefs that I'm seeking. And then we'll move over to statement of defense, which is also bound by the same set of rules. But every statement of defense must start with a general traverse paragraph. Every statement of defense must start with a general traverse paragraph. Because when we talk about statement of defense, it simply means a concise statement of the defendant denying the allegations against him as contained in the statement of claim, and also adducing his response in contradiction to the factual pleadings in the statement of claim. And how does one couch the traverse paragraph? That is paragraph number 1. As a defendant, your heading, after you have done the heading of the court, names of the parties, the title of your pleading is what? Statement of defense. Paragraph 1 says, save as hereinafter admitted, the defendant hereby specifically denies each and every allegation of fact as contained in the statement of claim, as if same were set out and denied seriety. And the defendant shall at the trial put the claimant to the strictest proof thereof. You're done with your paragraph 1. So paragraph 1 has shown an evasive denial that whatever you're going to say here, except the one I admit, everything is what is denied. And then that I'm going to address them in seriety. And then you come to paragraph 2. Let's say your paragraph 2 is addressing his paragraph 1. And in paragraph 1, he has already, described himself as the owner of so. If you admit, you say, the defendant admits paragraph 1 of the statement of claim. That's all. If there is any paragraph in the statement of claim that the defendant does not admit, what does he do? You first of all deny, and then you provide your answer. Let's say, for instance, defendant has said, I'm a direct son of so person who deforested the land. My denial is, the defendant denies paragraph 7 of the statement of claim and shall at the trial put the claimant to the strictest proof thereof. In response, the defendant hereby states that the claimant is not the direct son of so person. And then I continue by telling my story. So if I'm looking at a particular paragraph that I'm writing and the thing is becoming too lengthy, I can break it. What's the problem? He said what? Return leader, let him go and lead them now. So if he's so verbal, if he's getting too lengthy, what you simply do is to do what? To cut it and move over to the next paragraph. The idea is that what you're presenting must be succinct. Somebody reading it will interest the person. If you see a paragraph that covers 1 page, men looking at it will be tired. It's like at times somebody will forward something to your WhatsApp and you look at it and say, this way you want to punish me this morning. Who has time to read that? You understand? But if the thing is just like concert, you read a paragraph, successively you move to the next one, you move to the, and you're becoming interested in the story. So that is what it looks like, what we are expected to do. And then again, like I have said, all the rules applying to the pleading generally also applies to what? Statement of defense. And then in denial, like I have said, evasive denial is taken as what? Admission. Any denial that you can't provide particulars to it, you can't provide your own answer, means that you have what? You have not denied it. You have done what? You have admitted. Let's say, for instance, I'm saying the defendant denies paragraph 7, blah, 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 blah. The defendant states that the claimant is not the son of XYZ. And I stop. How did I know? Whose son is he? Do you understand? So there is still gaps that I'm yet to provide. Remember that he who asserts does what? Proves. And like I told you, civil litigation and criminal litigation is an intermixture of that very cause, and that's what? Law of evidence. So you must specifically deny, not to deny evasive. And there should be no argument, no legal argument, either in your statement of claim, your statement of defense, your reply, your rejoinder, and so on and so forth. So you are not obligated to do what? To argue. No legal argument. You are not also expected to quote law, but you can rely on legal principle in your statement of defense. You are not expected to quote law, but you can rely on what? Legal principle. Let's say, for instance, you have looked at the suit, and then you're convinced that this suit is stale. So what are you going to do? In one of your paragraphs, you say that the defendant shall at the trial contend that this suit is incompetent and constitutes abuse of the process of the court, in that it is stale, having been filed outside the statute of limitation. You are finished with that. So it's not for you to start arguing it there. All you need to do is that to mention what is wrong with it and tell us, anchor your point on any legal doctrine known to you without stating out section this, the case of this, no. There are people in their statement of defense, they will tell you, as was decided in so, there is nothing like that. So most of the times you meet a smart lawyer, he makes an application, my lord, paragraph this offense, paragraph of the rule, strike it out. By the time everything is struck out, you discover that it's solo. You don't have anything to rely on. So that's why you have to be careful to obey the rules of pleading. And now again, if for instance there is a document which your client is not in custody of the original, but the adverse party is in custody of the original, what do? You plead the secondary evidence and do what? Put the other party on notice to produce. Notice is hereby given to the claimant or to the defendant to produce the letter dated so. So the idea is that at the trial, if you fail to produce the letter, you do what? You simply tender the secondary evidence. So those are the things we also need to note. And then technical objections. A defendant can couch in a technical objection into his statement of defense. He can couch in a technical objection into his statement of defense. How would he do this? It simply means in a paragraph, you will mention maybe that legal change, assuming there was a condition precedent to bring in the action which the claimant has failed to fulfill. You say at the trial, the claimant shall raise the issue that the claimant has failed to satisfy a condition precedent to institute the case, to which non-service of reaction notice. You're done with that. That's a technical objection. So that at the trial, you may bring a motion asking the court to set down paragraph 32 and to determine whether the non-service of reaction notice has rendered incompetent the writ of summons and statement of claim. That is technical objection. So it is allowed for you to bring it out. Now also, if a counterclaim, if a defendant is desirous of raising a counterclaim, he can do so on his statement of defense. He can do so on the statement of defense, provided that he has provided enough facts upon which he can anchor his counterclaim, provided he has produced or pleaded enough facts. And now you may want to ask, does it mean maybe a defendant who has traversed the statement of claim, maybe down to paragraph 32, will now start afresh again and be doing all those facts in order to rely on what? The counterclaim? No. You can do it in one or two. There are two options. The first option is that assuming my denial and response to statement of claim stopped at 33, paragraph 33. I can now, after that, I'll write a subheading, counterclaim. And I'll write 34 without writing one again. I'll now say that the defendant shall rely on the interwoven facts in the pleadings. The defendant shall rely on the interwoven facts in the pleadings to raise a counterclaim, and hereby raise a counterclaim as follows. One, a declaration this, a declaration that. Some of those are damages. This is one of the ways of doing it. But if I don't want to apply that method, I can also say in my paragraph 34, instead of relying on the interwoven facts, I'll simply say the defendant shall at the trial raise a counterclaim and shall rely on paragraph 1 to 33 of the statement of defense. And the said paragraphs are hereby adopted as facts upon which the counterclaim is found. The next one, the defendant hereby counterclaims as follows. You put your counterclaim. So those are the two methods of raising a counterclaim. Right. So the same rule, like I said, applies in reply. Reply is not expected to be a reopening of your pleading. Reply, you simply look at those fresh issues raised by the defendant. Reply is usually filed by who? The claimant. After reading the statement of defense and you discover that he has raised something new that you did not cover, of course, there must be things you didn't cover because you were not in his mind. You didn't know what he was going to say. Because the law knows that there is a possibility of concoction of facts. That's why the law has given the claimant the right to what? Reply. So that in your reply, you will simply start your first paragraph by saying that upon being served with the statement of defense, the claimant notices or has noticed some fresh issues which shall be hereby addressed. You now, paragraph by paragraph, you start addressing them. Now, let's say while you are doing your reply, you have also raised some fresh issues which have gone outside the purview of the reply. The defendant can do what? Do a rejoinder. His paragraph 1 simply says the defendant hereby just issues with the facts as stated in the statement of as stated in what? In reply of the claimant. And then you now begin to rejoin some of those facts that are fresh too, that he has not been able to respond. But a court of law must make sure that the usage of these processes is not at large. You don't just say anything you want to do. Whatever you're saying is going to be within the context of what the other party has said, especially when the other party doesn't have any further right of reply. So if a party who doesn't have any further right of reply feels maybe aggrieved by fresh facts when he can no longer reply, what we simply do is to do what? Ask that the court strike out those paragraphs. You can ask that the court strikes out those paragraphs.